appeal part heard in the matter of Bilta Ltd and Parker and SVS Securities PLC and others.
Yes, Mr. Parker. We received your written opening and closing.
Thank you.
Court below.
Now, yesterday on the cost appeal, I had developed the point that we had made in paragraph 42 of our skeleton argument, namely that the judge erred as a matter of law in disregarding the size of the sum that TFS agreed to pay by way of substantive liability. And in that regard, we direct your attention to paragraph 11 of the judgment on page 185. It's the penultimate sentence and the last sentence.
Sorry, just a minute. 185. Yes. Yeah.
Because he said, let me say at once, it is sufficiently substantial in terms of monetary recovery not to cause the claimant to be disentitled to costs and grounds of succeeding a claim by recovering only a de minimis amount. The amount recovered is relatively de minimis. Our submission on that is the judge appeared to recognise that if the sum had been, if the amount to be paid by way of substantive liability had been established following a contested hearing, that in those circumstances the claimant was likely to get its costs because of the general rule.
Yes, but he does record, doesn't he, that neither side was asking him to apply the general rule. He says that at paragraph 9.
Yes, my Lord, which is puzzling because the whole premise of the submission that we should have our costs up to the settlement agreement was because we had been successful on the three substantive issues that were the subject of the settlement agreement. And then, having discussed the strictures that he considered he was operating on because the success had been by way of a settlement agreement, one sees paragraph 20.
But sorry, can I just ask you this? Let us suppose that the case had gone to trial, and let us suppose that all claimants succeeded on fraudulent trading, party 2 carrying on a business knowingly, but 3 of them failed because their claims were statute barred.
No.
You couldn't then say that they would be entitled, those claimants would be entitled to all their costs, would you?
Well, the primary submission would have been that costs should be determined in that scenario on an issue basis. The vast majority of the costs...
Well, it might have been, and it might not have been. But the Bilta venture, and I've forgotten the other one's name, would have failed.
Indeed, if one simply looked at the event and awarded costs in accordance to the event, your Lordship's quite right. We say in those circumstances, having regard to the salutary rule and encouraging people to concede issues that ultimately they're going to lose upon, that the court would have been inclined, a court acting reasonably would have been inclined to look at the question of the issues and would either have said the parties should receive their costs according to the issues, with the vast majority of costs, as say, having been incurred on establishing fraud, or would have said no orders to costs in respect of those 3 claimants.
Or it could have said TFS should get its costs subject to a substantial deduction for the issues on which it lost.
But possibly. But
I mean, there are all sorts of different possibilities that
indeed, but a substantial deduction on the basis of the issues that are lost because of the disparity in the amount of costs that were incurred on the substantive liability issues compared to the procedural defence of limitation. Obviously, I don't rely upon the technicality of substantive and procedural, but just in terms of the costs, establishing that the directors of the claimant companies were engaged in the MT fraud and establishing dishonesty on the part of the defendants, and then engaging in the exercise of quantum, substantial costs, all of which would have been avoided by a concession on those issues, then one obviously would have simply had the much less expensive determination of the issue of limitation. We say, therefore, as a matter of justice, that would be recognised by the court. And we'll see in due course the court's emphasis on the fact that in the context of late settlements, the court is very conscious of the fact that it was open to the defendants to concede the issues from the outset.
But my lord is right, isn't it? If one imagines that this litigation, instead of being 5 claimants against TFS, had been 2 sets of proceedings not formally consolidated, the three unsuccessful claimants had gone through the ropes. They'd proved that if they were to win, they would get X, but they lose all down the line because of limitation or whatever it may be. Then the starting point would be that the defendants would get their costs in that action. And if the others claimants won but lost on some important issues, the starting point, if the court was persuaded that the outcome was that they had effectively won, was that those 2 claimants would get their costs subject to deductions, possibly if the judge was persuaded on certain issues.
But my lord, as a starting point, yes, our response to that would be to urge the application of the salutary rule. And I appreciate McGowan and Langer was a case where there was actually a division of the proceedings, where certain issues were being determined in one stage of the proceedings, with the other issues being determined in another. And obviously, we say in our case that was what happened because of the settlement agreement. Certain issues were hived off.
But you have to say not merely that another judge would have done this, but this judge was wrong not to have done it. And cases like McGowan and Langer, whatever it was called, they're cases where an attack is made on the judge's discretion, and the attack fails because it's within the judge's discretion to do what he did.
Yes, my lord, but this was an error of principle because the judge proceeded on the basis that we were advocating, that look at the costs down to the date of the settlement agreement. And having done that, he didn't then apply the salutary rule because he took the view that he couldn't have regard to the confidential percentage. And we say that was an error of law.
Yeah, no, I follow
That's
that.
the
You say that it's not necessary for a judge to second guess the outcome of the trial, where the settlement agreement provides a good proxy for the outcome.
My lord, your lordship has the submission. My lord, I'll try not to be too long about it, but paragraph 20 of the judgment 187 is the distinction he's drawing between success that's achieved by way of a contested hearing and success that's achieved by way of a settlement agreement. And he says at paragraph 20, the payment to the club by TOX claimants arises by way of settlement, not a finding of liability, and the settlement provides no element of vindication or indication of outcome. Well, in terms of vindication, it is difficult to see why a claimant is only vindicated if the success is achieved by a contested hearing. So that which would give him his costs if he had established it by way of a contested hearing doesn't give him his costs simply because it was reached by way of a settlement. And turning to the 2 authorities that were before the trial judge, the first is the BCT Software Solutions Limited, C. Brewer and Sons, tab 74.
Yes.
It is our submission that the observations about the difficulties that settlement agreements can give rise to when one's considering the question of cost are outlined, but only in circumstances where it isn't clear, it isn't reasonably clear from the settlement terms who the winner is. And we say there's observations to that effect in the judgment of Lord Justice Mummery. If one goes to paragraph 4 on page 1614, one sees in the second sentence there are no doubt straightforward cases in which it is reasonably clear from the terms of the settlement that there is a winner and a loser in litigation. And then moving on to paragraph 7, I think it's the fourth sentence. If on the one hand the action is for damages, it will be relatively easy for the judge to tell from the size of the settlement sum and from the litigation history how the cost should be borne. And obviously this was effectively a claim for damages, and therefore we say it's relatively easy, was relatively easy, as the judge acknowledged, but for the fact of the settlement, to tell from the size of the settlement sum how the cost should be borne. And then paragraph 17. The BTC submission the judge should have made no orders to costs is particularly difficult to accept. That form of order certainly has its attraction in cases where it is difficult to fathom from the terms of the settlement who is the winner and who is the loser. Obviously,
now, BCT was a case where there was a claim for money. You know that, I think, from paragraph 10, whether Brewer was making use of the software outside the license, whether it should pay a larger annual fee and additional fees. And so BCT started its claim. Under the terms of the compromise, BCT recovered £10,000. And both Lord Justice Mummery and Lord Justice Chadwick said that in those circumstances they would not have embarked on the question of costs. They would have made no.
Well, yes.
The judge, I think it was Judge Rich, didn't, and they said effectively that's within his discretion.
Well,
but they would not have done. So on those facts, it would not have been an error of principle for a judge not to have made an order for costs.
well, yes. In circumstances where the total sum recovered in the settlement was £10,000.
Well, we don't know how much was claimed.
No, well,
I don't think we do it.
well, and the cost of the action were likely to exceed £300,000 on each side. And well, obviously, those factual circumstances, there's no suggestion that they apply here. That the sum recovered was effectively dwarfed by the costs involved, so that the claimant could hardly say engaging in the litigation was a commercial success. And then similarly, my Lord, to like effect in our submission, the observations of Lord Newberger in the Crown and Croydon case at tab 78.
Yes.
And at paragraph 45, picking on my Lordship's point, paragraph 44, the three relevant general principles. The first is that cost is primarily a matter of the discretion of the trial judge. The second,
You're at paragraph 44?
44,
Yeah.
1666.
Yes.
And the secondly is that it has long been the case in English civil litigation, and expressly stated in 44.3.2, the general rule in all civil litigation is that the successful party can look at the unsuccessful party for his costs. And then moving on to observations with respect to the settlement. 1667.
Yeah.
Discussing the BCT software solutions. Lord Justice Chadwick there said there will be cases, perhaps many cases, and it would be clear that there's only one issue, that one party has been successful on that issue, and that conduct is not a factor which could displace the general rule. This has seemed to be clearly right, given the normal principle of political costs when litigation goes to trial. It is hard to see why a claimant who, after complying with any relevant protocol and issuing proceedings, is accorded by consent all the relief he seeks, should not recover his costs from the defendant, at least in the absence of some good reason to the contrary. In particular, it seems to me there is no ground for refusing the claimant his costs simply on the ground that he was accorded such relief by the defendants, conceding it in a consent order, rather than by the court ordering it after contested hearing. In the words of CPR 4432, the claimant is every bit as much a successful party as he would have been if he had won after a trial. In 50, the outcome will normally be different in cases where the consent...
You don't need to read this aloud, Mr. Parker.
my
You
Lord.
want us to read paragraph 50?
My Lord, yes.
And 51?
50 and 51, my Lord. I figure I'll read back the bits I rely on, my Lord.
Yes.
So obviously we rely in particular on that first half of paragraph 50. And then we highlight paragraph 51. In many cases which are settled on terms which do not accord with the relief which the claimant has sought, the court will not normally be able to decide who has won, and therefore will not make any orders to costs.
Yeah.
And then the categories 1, 2 and 3 are introduced from paragraph 60 to 63, pages 1671 to 1672, if you scan us to read that.
Yes. The judge thought this was a case 2 case.
Do
you quarrel with that?
Yes, my lord, because the judge was dealing with the costs of the issues that were addressed by the settlement agreement. And on those issues, we say it was tolerably clear that we had been successful.
Well, you didn't get all the relief you were seeking, did you?
We got,
you got a proportion of it.
My lord, yes, a proportion which the judge recognised that if we had achieved that proportion as a result of a contested hearing, we would have been entitled to our costs. So as a matter of principle, the judge was saying you would have got your costs if you had established this by way of a contested hearing. But because this is by way of a settlement, and as we talked about yesterday, he felt that put him in a different position, he made no order. And we say that what appears from the two cases we looked at, the question is it tolerably clear who has won? And we don't believe that Lord Neuberger was insisting you only get your costs if it's a total capitulation. He talks about whether or not the claimant is vindicated. And we say, clearly we're vindicated. The judge recognised if we'd got this by way of a contested hearing, we'd have been vindicated. But he says, because we got it by way of settlement, we weren't. And we also say that Lord Neuberger makes it absolutely clear that when one's considering the question of who has won, there's no difference between whether you've achieved that by way of a contested hearing or whether you've achieved that by way of a settlement.
A similar argument is often expressed slightly differently, which is where a settlement has the obvious feature that both sides are buying off risk, and so you can't simply extrapolate from the settlement figure to what the figure would have been. But one argument that is often advanced, which I'm not sure I'm hearing very loud and clear from you at the moment, is that we had to do this in order to get this far, and once it's not a de minimis recovery, we shouldn't be penalised by the fact that we've saved the court time by settling our differences and maybe coming out, particularly if it's a figure which on the courts or on this judge's finding, had he awarded that figure, he would have given you your costs of the issue.
Well, yes, that is that is the point that we
You're
make.
going to show me in your skeleton exactly where you say just that.
Well, yes, I think it's a point that Lord Newberger makes on the question of settlement, that the answer is, I'm sorry, this is very point. Your Lordship may appreciate that. That's the very point that when one's considering, it's a point that's made in the context of contested hearings in the Budgeon case that Your Lordship may be familiar with, which is it's mentioned in the Budgeon case is picked up in one of the authorities that my learned friends are relying upon. I will leave them to develop.
Sorry, which case?
It's the Budgeon case. If we look at Capita, my lord, which we have tab 82.
Yes.
Do you by chance have a page number?
Begins at 1727.
Thank you
It
very
does.
much.
It does. And this is relied upon in my learned friend's skeleton argument, paragraph 88, on the basis of asserting there's no rule just because a claimant made a substantial monetary recovery, there must be a cost order in its favour. And that's obviously right. And the claim in Capita succeeded as to 50%. But for the period up to the defendant's Calderboat offer, no order for costs was made because the reduced recovery was the result of the defendant's success on an issue on which the majority of the costs had been incurred. Very different facts to this. But we say the important thing is that the judge in Capita had recognised that a substantial monetary recovery would usually give rise to a cost order in the claimant's favour at paragraph 17. Now, obviously, the judge there noted that against that, there were two features of the case, namely that for a long period the claimant had been pursuing an all or nothing approach, and that's paragraph 18. And secondly, this is paragraph 19, that they lost the claim on an issue, which is the transfer date issue, on which the judge had judged the majority of costs on both sides to have been incurred. So this is a case where a party brought a claim to an indemnity that had been provided by the vendor of the business. And the response was to say, we're not liable after a certain date. And that defence was upheld. And as the judge noted, the majority of the costs in that case had been incurred on an issue on which the defendants had been successful. And again, not our case. But the judge here starts from the general rule, costs in respect of costs are awarded despite the 50% only being 50%. Then he identifies countervailing factors that displace that rule. That contrast here, where the judge dealing with the issues up to the date of the settlement agreement recognised that if the position had been reached by way of a contested hearing, we'd be entitled to our costs, but then didn't give us our costs simply because we've got to that position by way of a settlement agreement.
Just show me where he says that, please.
So
Where does the judge say that? Just remind me.
my lord, we say the recognition that we would have got our costs if this were by way of a contested hearing. We say is paragraph 11. 22, page 185.
So you say, do you, that if this has gone to hearings, putting up a point that I perhaps asked you before, and 3 claimants had lost and 2 had won, all 5 would have got their costs. You say the judge has said that somewhere.
No. I said what I say the judge has said. If there had been a split trial, if there had been a trial of substantive liability followed by a separate trial of limitation, the judge has said that we would have got our costs of success on substantive liability.
Yeah. Where does he say that?
Well, my Lord, I'd say that that's the clear inference from paragraph 11, the penultimate sentence.
He's saying that you're not disentitled to costs on the ground of recovering only a de minimis amount.
My Lord, yes. Which we say is a
So
recognition.
you're not debarred from recovering costs on that basis, and therefore you say it must follow that you would have got your costs. Is that how you interpret that?
Well, Lord, because that would be in accordance with the usual rule, as we'll come on to it.
Well, I follow the usual rule, but I thought you said the judge had said that had it gone to trial and had you recovered what the settlement agreement gave you,
My Lord, yes. Because
and 3 claimants had failed and 2 had succeeded, you would all have got your costs, and I didn't see that in his judgment.
my Lord, at the moment we're not discussing the question of subsequent failure because we're dealing with this on the basis of the settlement agreement, the substantive issues having been dealt with separately. On the basis they're dealt with separately, he's saying that in effect we would have our costs and we wouldn't be disentitled from having our costs because the amount wasn't large enough. So this we say is a clear recognition that on the basis of things being dealt with separately in the way we've discussed, that we would have got our costs.
Yeah.
But
And we would have been
if one had been if it had been done substantively, and Mr. Scory had lost the issues that were in the settlement, he would, I'm reasonably confident, or should have got up and said, "Don't make an absolute order in respect of this issue because they may lose overall."
And my Lord, and we say that's why McEwen and Langer is pertinent to this, because McEwen and Langer says it's a salutary rule that you award the costs in accordance with the particular stage of the proceedings, and you don't.
But that doesn't apply if it's contingent, any more than if you bring a strikeout and the claimant succeeds in resisting the strikeout, you don't automatically give the costs of the strikeout because the courts will frequently say, but this may all be a complete waste of time because you may lose hands down when we get to a trial.
But my Lord, that isn't separating out the issues. If you lose a strikeout, then the issue carries on. The issue has not been determined. If the issue has been determined, then McEwen and Langer is on the basis that you do award the cost of that particular issue. All issues, and this is the point, they say, but the settlement agreement is conditional. All issues are conditional on other issues. The ultimate legal consequences of those legal issues are usually conditional on the outcome of other issues. But that isn't a reason for saying, in circumstances where they're being dealt with separately, you don't get the costs of those issues. And we say that's the message.
You may get the costs of those issues.
I'm sorry, my Lord. But if the salutary rule is applied,
Yeah.
then in those circumstances you're likely to get your costs.
I don't, if I may say so, I don't think it helps terribly much to inquire what cost order the judge would have made if the facts had been different. The facts are as they are. He was called upon to exercise his discretion on the facts as they are.
Well, my Lord, I appreciate that, but it comes back to identifying an error of principle, because obviously one cannot simply say it was within the judge's discretion if the judge has proceeded on an erroneous legal
Well, I
basis.
follow that, and your
we
point
say,
of principle is the judge was wrong not to have taken the settlement agreement as a good proxy for the outcome of the trial.
well, it's not a proxy, my Lord, for the outcome of the trial. We say it's identical. You read what the settlement terms. This is a claim compensation, claim for damages, and you can see on the issues of substantive liability what we have recovered, subject to the limitation defence. But in terms of the substantive issues that are the subject of the settlement agreement, it's very simple. We've received the confidential percentage,
Yeah.
and the judge is recognising that if we had got to that position following a contested hearing, we would have been entitled to our costs. But he makes no order because we haven't got to that position.
You wouldn't have been disentitled because it was de minimis, which is different.
Yes, we were entitled, and we wouldn't have been disentitled because it's de minimis. But
I mean, are you saying, I'm conscious of the authorities you've referred to, but are you saying that it would have been wrong in principle had you contested the issues separately that were bound up in the settlement agreement and reached the result, for the judge at that point to say, I'm going to reserve the question of costs until I know the outcome of the action as a whole.
It would have been contrary to the salutary rule.
Would it have been wrong in
And-
principle?
and
So as
again-
to require this court to intervene? Because at the moment, I think the answer is no.
And it is clear that that is not what the judge was doing. That is clear from, if one goes to, sorry, it's paragraph 24, page 188.
Yeah.
The court there's, if the court reads paragraph 24 and one sees this point about the conditionality of being put by TFS and the judge responding, seems to me accepting that an issue-based cost order is appropriate, the outcome of such an order cannot be informed by other issues unrelated to that issue. Such an approach undermines the whole point of an issues-based cost order, which is to identify who won which issues. So the judge was not saying, well, I'm not going to award the cost that I would have awarded if this had been a contested hearing because we still have the limitation issue. The judge is specifically saying, no, the whole point of looking at each issue is you award the cost of that issue, irrespective of what might happen with other issues. So it's not the approach that the judge took. Now, entirely accept this court, if in terms of exercising a discretion afresh, this court will be perhaps looking at it as this court wants to do so. But for the moment, I think I'm being taxed on the question of whether or not the judge had made an error of legal principle. And I say he did, because our position is he had it right in saying, well, I'm going to deal with the position up to the settlement agreement. He had it right in acknowledging that there's no reason to disentitle us from our costs of being successful in those issues had it been a contested hearing. And the error of law was to say, but because the claimants got to that position, which it could only get to after pursuing the legal proceedings, it can only get to that position, they're not going to get their costs because it's been arrived at by way of settlement. And that's the error, we say, of legal principle.
Can I rephrase it slightly? You're saying you didn't get anything for substantial success achieved by way of settlement of those issues.
I'm sorry, no.
You didn't get anything. There's nothing in his order that reflects the fact that you achieved substantial success
Yes.
on those issues.
Yes.
Full stop. Is there anything more to it than that? I mean, we can encrust it with authority as much as we like, but that's your complaint, isn't it?
Well, it is. It is our
And
complaint.
then we have to decide whether that's an error of principle that entitles us,
Well,
requires us to intervene.
and I was seeking to identify the reason why we didn't get anything. And the reason why we didn't get anything is because the trial judge said, you'd have got it if it had been a contested hearing. You don't get it because of settlement, because of the problems we talked about at the end of yesterday. I don't want to trespass on the court's time more than necessary. My final observation is just to deal with a point that I make in paragraph 34 of my skeleton arguments on page 28. And if the court has that, paragraph 34,
Yeah.
page 28, the defendants have redacted that as being a confidential matter. So I wonder if the court is kind of just to read it.
Yes.
Those are my submissions. Thank you very much.
Right. Just before you finish completely, can I just ask you this? It really arises out of what we discussed yesterday. We've got Mr. Scory's appeal on section 213 and your appeal on section 1032. If Mr. Scory loses on 213, does 1032 arise at all?
Well, in terms of affecting the outcome of the case, no, it doesn't.
Are you asking us to decide it, irrespective of what we decide on 213?
Well, I'm just conscious about what might happen if the matter goes further.
Right.
So, yes.
So I think the answer is yes. Yeah, right. Thank you. Yes, Mr. Scory.
Because they are, my lord, different claims of different parties.
Yes, that's true. One is by liquidators and one's by the companies themselves, yes. Yes, Mr. Emmett, you're going to deal with costs, are you?
I am, yes, my lords. As I understand it, my learned friend's argument has essentially two planks, and he has to succeed on both if he is to succeed. And he has to succeed to the standard of showing that the judgment was manifestly unjust. It's not just enough to establish that another result might have been better. The first thing he says is that the judge should have treated the compromise agreement as though it amounted to the judicial determination of a stage in the dispute. And I say that is wrong because, as a matter of fact, by the time of the compromise agreement, substantial costs had been incurred on issues that were left out of the compromise agreement. So it would be unfair to assume that all of the issues in the case on which costs had been incurred up to the date of the compromise were compromised. In fact, very substantial costs on limitations had already been incurred. And in any event, that there is substantial overlap between the costs of the different issues. I also say that it's the wrong approach in principle. It's clear from the authorities, and in fact it would be clear just on first principles if one approached it as a matter of analysis, that a settlement is not the same thing as a judicial determination, and that one should not approach the question of costs as though it were. My lords, the second thing that my learned friend says is that once if he can get over the first hurdle, he says, well, they essentially won the settlement. They say you can treat it in, well, he actually balked rightly at the suggestion from my lord that one could treat the settlement as a proxy. But he said, well, if you look at the terms of the settlement, we won because you can see from the terms that essentially we're the winner. And I say that's wrong on two counts. That is wrong because the compromise was conditional, so it potentially gave them nothing at all, depending on the resolution of other issues. And in any event, under the terms of the settlement, there was a substantial reduction in what they could have recovered. So it's not right to say that you can just look at the settlement and assume that the claimants won the issues that were compromised under it. Now, my lords, my lady, can I just turn very shortly to the issue of whether the settlement could be treated as a proxy for what would have happened if the case had gone to trial. My learned friend was resistant to it, and it is good that he was resistant to it, and he was right to resist his suggestion, because what actually happened is that this judge knew the case very well. He had heard a number of interlocutory hearings. He heard a CMC very early in the piece, before even I was involved, and he heard a PTR. He had in fact had two abortive attempts to hear a trial, heard a trial, and then heard the consequentials argument. And he did not think that the settlement agreement was any kind of helpful proxy as to what would have happened if the case had gone to trial. And it is quite right in those circumstances.
But that was because he simply said, I can't predict what would have happened at trial. That's his underlying reason for not treating
well, that is the conclusion that is the view that he formed on the evidence. But he did not think that he could answer that question by looking at the terms of the settlement agreement. So one way of answering the question might have been to look at the terms of the settlement And there was actually debate about why the settlement might have been what it was between my learned friend and the judge at the consequentials hearing. And the judge said during the course of argument, he gave some of the reasons why he thought it might not be, or why it was not an indicator as to what the result would have been.
But suppose you bring a claim in, let's say, professional negligence.
Yes.
And you quantify your claim at £1 million.
Yes.
And the parties settle for 250,000, let's suppose.
Yes.
You might, in those circumstances, say, well, I don't know what would have happened at trial.
Yes.
I really have no idea what would happen at trial. But I do see the defendants have agreed to pay £250,000, and I'll take that as the proxy. I mean, that wouldn't be unfair, would it?
Well, in my submission, it would be. If those are the only facts one has, that would be unfair. You have no idea why the defendant might have agreed to pay £250,000, and you also have, just on the facts as you've described them, my lord, you would have no idea as to what the costs were and how they had been incurred. I mean, for example, it might be a case where the establishment of liability was a very straightforward matter. I don't mean straightforward in the sense that the claimant would definitely have won, but it just turned on a very straightforward resolution of fact as to whether person X said A or B at a certain meeting. And it might be that that issue gave rise to no costs, or minimal costs, whereas in fact most of the costs up to the time of the settlement had been incurred on issues of quantum. And it could be in those circumstances that in fact if you were looking at the costs, the defendant was very substantially the winner in terms of what had been resolved and how you got there. So I don't agree with the proposition that you can read from the result to the of the settlement to the costs outcome.
Although some of the cases say you can.
Well, they say when it's very clear, but they do distinguish cases where the claimant has really got everything from cases where they've got some of what they're
It's
after.
one of the reasons why settlements are such a fertile source of secondary litigation alleging negligence on behalf of the advisors, particularly when you go, as it were, to deal with a liability-only trial and then settle the whole thing at the door of the court, and someone comes up and says, but you can't, you didn't take account of this, you didn't take account of that, and so on and so forth. It's the same problem, I think, as you're talking about, coming from a different angle.
Yes. Well, that's right.
But it does depend slightly on the figures, doesn't it? I mean, the nearer you get to full recovery by a claimant, unconditional full recovery by a claimant, the weaker the argument becomes that you don't know what's going on.
Well, my lords, if one just takes that proposition, then that may be right. Because if one recovers 99%, well, that's obviously very nearly 100. But we're not in a situation where the reduction was de minimis. The reduction was substantial. Now, there's disagreement between us as to what the extent of the reduction was. I say that once you take interest into account, it's really rather a more substantial reduction than my learned friend says it is, because there was a reduction. But I'm not going to debate that in open court, because that would involve going into the confidential terms. So you have that point. But the other point which we need to bear in mind is that in this case, we're not dealing with a settlement which resolved everything up to a figure. It was a settlement in which everything was conditional. It was a settlement in which the claimants might end up with nothing at all. And so in this sort of case, even if the figure had been 100%, I don't accept that there would necessarily have been...
But there's nothing exceptional about that. That's a bit like settling quantum and fighting on liability.
Well, there's nothing exceptional about it, my lord, but it does have the effect that one simply can't read from the settlement of one issue into the overall outcome of the case. Particularly where, in this case, that there are overlapping costs between the different issues. And where my learned friend actually wants to use this point, not just to get the overlapping costs, but to get all of his costs of limitation up to the date of the settlement.
Apart from Mr. Hellard's witness statement.
Well, not Mr. Hellard's witness statement, but those are by no means the only costs. And what's more, he takes no account of our costs incurred on limitation up to the date of the compromise
well,
agreement.
no doubt there would have been statements of case, disclosure, inspection, etc., etc.
Yes. My Lord, there's evidence on this in the bundle, and I'll come to it. Mr. Zabetti, those instructing me, set out an estimate as to how many of our costs were incurred on the different issues. So this was all canvassed before the judge, and he was well aware of these immense difficulties.
Yeah.
My Lords and my Lady, I was going to proceed under 4 heads. First, I want very shortly to address the standard of appellate review. Secondly, I wanted to run through a couple more points to arise out of the cases. And then thirdly and fourthly, I was going to address what I described as the 2 planks of my own friend's case. On the standard of appellate review, you are very familiar with the principles that arise normally in relation to appeals against discretionary cost decisions. For what it's worth, they're set out in our skeleton argument at footnote 12 at page 61 of the core bundle. And you will also be familiar with the point that once
You
you
say
seek
it's a heightened test, it's got to be manifest injustice.
My Lord, that's a conflation of 2 points. So that is, first of all, there is the normal test of, yes, and you have the point from BCT that it's a heightened case when one is a heightened test when one is appealing against a decision made
After settlement.
after a settlement.
Yep.
Yes. And the other point which you have well in mind is, of course, that when one comes to read the judgment, one should read it on the basis that the judge knew what he was doing, and that the suggestion that he lost sight of X or Y shouldn't be accepted merely because X or Y was not mentioned in the judgment. My Lords, that brings me to the second head of my submissions, which was the approach to be taken in cases such as this, and what is said about that approach in the authorities. Now, there's no dispute that the court was entitled to, or the judge was entitled to adopt the approach he did. For what it's worth, the approach of separating out pre- and post-compromise costs as though there had been a bright line was the approach recommended by the claimants. Our starting position before the judge at the consequentials hearing, and would be, if the decision were to be overturned, that one does start from the proposition that 3 of these claimants failed, namely Bilta, Western, and Vehement, and only 2 of them achieved orders in their favour. And there were substantial, really very substantial costs that were referable to the individual claims. And in particular, those costs related to the expert evidence, which went to the establishment of deal chains relating to the trades carried out that led to losses by each of the 5 different claimants, and also relating, in some instances, to, for example, whether trades had actually been brokered. So that the quantum of the claim involved a substantial number of very detailed issues, which were different as between the different claimants, because there were different companies trading on different dates and then trading with different counterparties. So, as I say, our submission was that the judge...
That's all in the evidence somewhere, is it?
That is dealt with in... the points are outlined in Mr. Zabetti's statement, but if you're going to have to go back into it, I think you would need to see more than just is here. We'd need to at least give you the skeletons from the consequentials hearing and probably the evidence that would have been before the judge. And that's one of the many reasons that I say that if you're minded to overturn the judge's cost order, he is by far the best person to deal with those issues. Now, my lords, I say it's relevant that the approach was one recommended by the claimants, just because in BCT, you may recall that Lord Justice Mummery said at paragraph 17 that it was particularly difficult to accept the criticisms of the judge that had been mounted by the appellant in that case. And I don't propose to take you back to it unless you'll be assisted, but actually if you read paragraphs 16, 17 and 18 together, the reason he says it's particularly difficult is that he has just recounted the inherent difficulties in resolving costs following a settlement. And what he was expressing was, I take it, reading between the lines, some irritation that the judge, having done his best to help the parties, and having done what the appellant in that case had asked him to do, namely resolve costs after a settlement, was then being criticised for having done what he'd been asked to do. And I say, really, again, this is the point, that this is what the claimants asked the court to do. The alternative would be to approach the case in the way we recommended. Having said that, my lords, I just wanted to add a couple of points to what my learned friend said about the authorities. If I could ask you to start by turning to Brawley and Marginski. That is at tab 75, the authorities. I think it's in your bundle 3, but I think we all have different numberings.
Yeah, starting at page 1621.
Yes, that's right. And I'm only going to refer to paragraphs 21 and 22, but if it would help to orient yourselves by reading the headnote, then do so. Paragraphs 21 and 22 at page 1627 and 1628.
We don't need to worry about indemnity costs, do we?
No, it really is just those two paragraphs.
Yeah.
And my lords and my lady, the key point I draw from those paragraphs is that where one is engaged in an exercise of this kind, the key question recommended by, first of all, Mr. Justice Scott Baker and then by this court in Brawley and Marginski, is who would have won if the case had gone to trial. And you see that at paragraph 22, that is what the court focused on in that particular case of Brawley. And I say that the judge in our case was right to focus on the question, who would have won had the case gone to trial. And I say, it in particular can't be said that he was so completely wrong that his decision on a discretionary cost matter should be overturned in circumstances where he focused on the issue that this court says should be the focus. Now, my lords and my lady, I was going to try to avoid going back to BCT and Brewer, but just very shortly, given that we have the authorities bundle open, can I draw your attention to, in addition to the paragraphs of Lord Justice Mummery's judgment that we've looked at, to what was said by Lord Justice Chadwick at paragraphs 23 to 26.
Can you give me a page, please?
That's page 1619.
Thank you.
And the point I make is that Lord Justice Chadwick, unsurprisingly, focused on the same matters as this court had done in Brawley and Marginski, namely, you were looking at agreed or determined facts in paragraph 23. And if you see, Lord Justice Chadwick returned to that halfway down paragraph 24, where there has been no trial and no judgment, the judge may well not be in a position to reach a decision on those matters, i.e. who has been successful, who unsuccessful. He will not be in a position to decide those matters if they turn on facts which have not been agreed or determined. So again, Lord Justice Chadwick focuses attention on what actually were the facts and who would have won. My lords and my lady, I don't need you to turn back to Croydon. The only point I would make, I think, is really just for your note, is that the dictum of Mr. Justice Scott Baker that was quoted in Brawley and Marginski was also quoted by Lord Neuberger at paragraph 32. And that is, I think, the full extent of my excursus into the authorities. And just before I leave this point, the approach to be adopted, I just wanted to reflect very shortly on why it is that courts gravitate so strongly towards no order as to costs in circumstances where there's a settlement that leaves you in between the two very ends of the spectrum of the possible outcomes. The first is that, as I've shown you in BCT and in Brawley, cost orders are normally based on factual findings and resolutions of actual disputes. And in a case where there's a settlement, the court does not have that as an anchor to ground or to stay its determination of costs. And that was what the judge focused on in this instance. Secondly, one sees expressions of caution in relation to cases that fall between, as I say, the two ends of the spectrum. And it's not suggested that the court can help itself by trying to read the tea leaves of settlement agreements that might seem to lean one way or the other. And there are good reasons for this. As was debated by my learned friend with the judge at the consequentials hearing, parties have all sorts of reasons for settling disputes that may have nothing to do with the merits. Could be reputational concerns, desire to avoid the publication of commercially sensitive information. There could be tactical forensic reasons for settling either one dispute to avoid harming a position adopted in another dispute, or in this case, potentially settling one issue by reference to its potential impact on other issues. So you really can't, you cannot look at the terms of a settlement as a basis for inferring the merits of the underlying dispute. It's also worth bearing in mind that a party's reasons for settling are likely to be intimately bound up with legal advice, and courts are rightly very slow to speculate as to what the advice might have been. And moreover, you cannot refer to the parties' communications with one another. They'll be probably uninformative, but in any event, it's particularly difficult in circumstances where you're almost certainly not got the full picture, because there'll be open communications without prejudice save as to costs communications, and fully without prejudice communications. So you're unlikely to have the full spectrum of the debate between the parties as to the negotiation of the settlement. And the third and obvious point is that in such a case, the parties themselves have obviously not agreed costs. So whichever party feels aggrieved obviously was unable to settle the case ex hypothesi on the basis of the costs that they feel they ought to receive. And that is in itself a reason for caution. My lords and my lady, that is everything I was going to say about the approach to be adopted. I now move to my learned friend's first point, which is that he says you should approach the settlement agreement as though it was the resolution of a series of preliminary issues or a stage in the argument. And as I said by way of introduction, that the first and short answer to that is that it's not correct as a matter of fact. And I alluded earlier to the fact there was evidence on this by Mr. Zabetti. It's in the supplemental bundle at tab 5. And what I was proposing, that there are rather helpfully very short paragraphs that just give figures for the costs of the different stages in the action on TFS's side by reference to estimates. So if I ask you to, if you just start at page 229, you see an estimate as to what should be done about TFS's pleading costs. That's at paragraph 21.
This was evidence for the consequentials hearing.
That's right, yes.
229.
229, you'll see there. Yeah, so, and just for information, really, you see there a reference to common and claimant-specific costs. That was relevant because it was our position at the consequentials hearing that one had to proceed on the basis that Bilta, Western, and Vehement had failed, and Nathaniel and Inline had succeeded. So,
Yeah.
and then again, the cost of the CMCs is at page 232, paragraph 30. A disclosure opposite that, if your bundle looks like mine, at page 233, that's paragraphs 34 and 35. Paragraph 38 is witness statements, that's page 234. Paragraph 40, page 235 is expert reports, and then the PTR and the trial preparation at pages 236 to 237. That's at pages 14 to 15.
Yes.
And of course, all of this was an attempt to break down costs that did to some extent also involve elements of overlap. So it most certainly is not right to say that all of the costs up to the time of the compromise agreement were referable to the issues that were compromised. Secondly, my second answer to my learned friend's point is that it is in principle wrong to treat a settlement as though it was a judicial determination. Now, I've made the point about it not being a proxy and the judge recognising that it wasn't a proxy already. And I've shown you the authorities, and we've already debated the example of the professional negligence claim. So I wasn't going to go further into this point unless you'd be assisted by it, and was going then to move immediately to my learned friend's second point, which is that he says he effectively won the settlement. This is the fourth of the four heads that I said I would make my submissions under. Now, by the way, I say that my learned friend didn't win the settlement for two very straightforward reasons. The first is that under the settlement or the compromise, whatever one calls it, there was a conditional entitlement only. That was all there was, and it left open the possibility, as indeed transpired, that Bilta, Western, and Vehement's claims failed in their entirety. And as I've shown you, that the costs, there were costs that were referable to specific claimants, and not just, it wasn't as though it was all just referable to the claim at large. I need to remind you that there was no admission of liability, so that it really cannot be said that they won the case factually. And as a last point, I don't need to overlap to the points I've made, but it is a very good test. But it's a very good test that what my learned friend wants you to do in relation to these costs is in itself unjust, because the order that he is seeking would leave TFS without any recovery of its costs on the issues that it won at trial, down to the date of the settlement, and leave the claimants recovering some of their costs of those issues that they lost. And that is a very good test for why his position is wrong. Now, my Lord, Well, look, and my lady, one other point just before I leave this, that my own friend seems from time to time to stray into saying that limitation was somehow a sort of lesser defence, and that if you win on issues other than limitation, really you've won. And limitation is a sort of a tail-end Charlie that just isn't really a proper defence. I said that's not right at all. And if anything, it's the other way around, because if one has been subject to a claim that is time-barred, then one has in fact been subject to the precise injustice and the precise mischief that the Limitation Acts seek to prevent, namely the prosecution of stale claims.
Well, if a limitation defence is raised, that's quite often tried as a preliminary issue before you get into the merits of the underlying claim.
My lord, my lady, it is, and it wasn't here. Now, these decisions would have been taken before I was involved, and I'm not sure that I'd be able to explain what had happened even if I had been involved, but it is at least worth bearing in mind that there were, I think, 4 or 5 other defendants, plus the claim was consolidated with a related claim against Citibank. So, and none of those other defendants had raised limitation issues. So the prospects of having a limitation-only trial as a preliminary issue here were, well, that of course certainly gave rise to difficulties, which it might not have in other cases. And in any event, it's not clear that would have worked in circumstances where there was factual overlap between limitation and the other issues. Now, for what it's worth, my learned friend referred yesterday to the decision of Mr. Justice Miles in case ERED and Trion. That was a case that it's not in the authorities bundle. We referred to it at the consequentials hearing. It was in fact a case in which my own friend Mr. Parker appeared.
I don't know that case. What does it say?
No, what I say, well, I have copies if my own friend's going to press it. What I say most certainly does not say is that there's any kind of presumption or principle that if a claim succeeds but fails on limitation, then there's no order as to costs. What actually happened in that case was that it's true, the claims largely succeeded, or would have succeeded, but for limitation defence, and then failed on the limitation defence. There was then a debate as to what cost order should be made, and all sorts of factors that you'll be very familiar with were debated about conduct and potential settlement, etc. And in the end, Mr. Justice Miles came to the conclusion that there should be no order as to costs. But that wasn't based on a principle, that was just based on an assessment of what he thought was the appropriate order, having heard a lengthy trial.
Yeah.
And there's nothing unusual about that at all. So that is the first reason that I say the claimants did not win the settlement. The second reason is that even the conditional entitlement was capped at an amount that was substantially less than what was claimed. Now, I alluded earlier to the fact that there may be a dispute between the parties as to precisely what the cap was or precisely what the proportional recovery was, depending on whether or not you take into account interest. Rather than debating that in open court, I'll just flag for your note the fact that that is at paragraph 73 to 75 of our skeleton argument.
Yeah, you give some figures.
Yes, that's right. Otherwise, I just wanted very shortly to run through the points that we make about this submission in our skeleton. And I'll just cross-reference as we go. The first is, of course, that the claimants had never made an offer to settle for an amount less than their conditional recovery under the compromise agreement. And in those circumstances, it's very hard to see why the claimants can say, well, we had to come this far to get the terms that were available in the compromise agreement, because they'd never offered them. But obviously, nobody really knows what would have happened if those terms had been offered earlier, but they'd never been offered, and so it took as long as it took to get to the result that was reached. Secondly, and I'm now looking at paragraph 78 of my skeleton argument. Sorry, I paused because I think I said paragraph 64 when I was talking about my first point. I should have said page 64. It's paragraph 77, page 64. This is paragraph 78. And as we say there, in circumstances where there's a money claim and no counterclaim, the only possible basis on which a settlement could be reached is that the defendant agrees to pay some proportion of the claim. And I'd be going over ground to say that you can't read from the fact that it's been settled, that there's been a settlement on those terms, that there must have been a good claim, because the only possible way to settle is to fix on a figure. And if it's half of what's claimed, well, that suggests that it was a toss-up. My lords and my lady, thirdly, at page 65, paragraph 79, the claimants seek to bolster their argument on this count by referring to their notices to admit. Now, we say that that doesn't help them at all. What that shows is that until the time of the settlement, what they'd want us to do was to roll over in our entirety.
Well, it's not a big point, but you can always respond to a notice to admit by making a partial admission.
Well,
couldn't you?
Well, we could have done, but they could have reduced the quantum of their claim or served the notice to admit in relation to any part of the claim. So, anyway, you have my point. Fourthly, and this is important, there was a dispute about quantum. And I do want to dwell on this because I would not want it to be thought that recovering a proportion of their costs, recovering a proportion of their claim meant that all of their costs had been vindicated. As I've said earlier, there was a substantial dispute as to how one composed the deal chains involving the different claimants and the different entities, which trades TFS had actually brokered. There was some dispute about trades which appeared that they come up in other parties' documentation, but we had no record of them. There are various issues of that kind. And even if the case had gone to trial and the claimants had recovered, in respect of every single claimant, a proportion of their claim, we would most certainly have said that they hadn't succeeded, at least in their entirety, on quantum, and might well have said that they'd failed on quantum. So
I mean, again, take a different example. The professional negligence claim quantifies it at £1 million, and the defendants say, no, your claim is only ever worth 250,000.
yes,
Case goes to trial,
yes,
and 250,000 is indeed awarded.
yes,
You would say in those circumstances the defendants are entitled to say, well, we won on the issue of quantum.
yes. Prima facie, and obviously you then have a lengthy argument of the kind we're all familiar with about to what extent one adopts an issues-based order.
Well, is it really as simple as that? Because as soon as you get into this example, the question then is, have you put your mouth where your money is? Have you put in a called bank or a Part 36? And then,
Yes.
if you put in a Part 36 of £250,000, you really can say, we've won. And the consequences are, from the date of the payment in, you get your cost, but not up to the date of the payment in. Not automatically.
No. Well, my lord, that's exactly right, and that's the sort of debate one would have. But one might also have a debate about where the costs had actually been incurred. Because as I said earlier, one might have an example where those were the facts, but actually the issue of liability all turned on what was said in one meeting. And let's suppose there's half a dozen documents in either that are relevant to that issue. All of the battleground is quantum.
But that's one of the clarifying beauties of a Part 36. And all we know is we have not been referred to a Part 36.
Well, that's right. And my learned friend hasn't referred you to Part 36 or called bank offer. That's the thing about settlement. It establishes a veil, and you can't.
But in your category, in the categorization that you're doing now of your paragraphs of your skeleton, you could have added, or of the same ilk would be the observation that people could have put in a Part 36, and so far as we're aware, have not done so.
My lord, absolutely right. Yes, that they could have offered to settle, and they didn't. And actually, that was my first point at paragraph 77, page 64.
No offer to settle.
Yes.
Fair enough.
Then the final 2 points, just to note them, are paragraphs 81 and 82. I don't actually have anything to add to them orally, so I'll let them lie. Likewise, there are points taken in response to individual arguments of my learned friends set out in paragraphs 83 to 91 of our skeleton. I wasn't proposing to address those orally, but they're there, and you see where they are. So, my lords and my lady, that brings me to the end of my 4 planks that I said I would address just shortly by way of conclusion. My key point is that the claimants do not come close to establishing that there was a manifest injustice in what the judge did. And on the contrary, in fact, the order that the claimants are seeking to make would itself give rise to a manifest injustice. That gives rise to a question. What should happen if you're against me? And as you know, my primary submission is that the issue of costs should be remitted to the trial judge. If you're against me on that, I think I need very shortly to set out what I would say you should do. And that is, first of all, you should proceed on the basis that Bilta, Western and Vehement have lost, and Nathaniel and Inline have won, and that many of the costs are referable to specific claims by specific claimants. Secondly, you would need to take into account that the claims of Inline and Nathaniel have not been wholly successful, and you would need to make an order which took account of the fact that even though successful claimants had not been successful in full. And thirdly, you would have to take into account the fact that there were issues on which we had won hands down. So we would be entitled to all of our costs of those issues. Now, this was in fact debated in the skeleton arguments at first instance for the consequentials hearing. What I was proposing, I've got them here in case my lords and my lady would be assisted by them, just to assist with that exercise, and I can hand them up. Or I can
Submissions for the consequentials.
Yes.
Well, yes.
They're relevant only if you're against me on the appeal and against me on the submission that it should be remitted to the trial judge.
Right. So if we're against you, if we're against you, the order stands, right? If we're with you.
No, if you're with me, the order stands. The costs order stands.
Yes, sorry.
Yes.
Yeah. If we're against you, then you want to discharge paragraphs 3, 4, 5 and 6 of the cost order.
Yes, and it has to go back to the trial judge. And as I say, if you're against me on that course, that it be remitted to the trial judge, then these skeletons will be relevant.
Yeah.
Shall I?
Well, by all means, hand them in.
Yeah.
Could we have them electronically?
Yes, I'll do that rather
as
than...
well as...
as well. Okay, yes. Could I... And my lords and my lady, just very shortly, before I sit down, there is, of course, the question as to what would happen if you agree with us on section 213 and agree with us and the judge on section 103.2.
Oh, well, if
in that case, the cost
the
of the
judge's
action will be...
substantive orders are
Yes.
altered, then costs are up.
Then we'll be asking, yes, that's right. Yes. And unless I can assist further, that is what?
Thank you very much, Mr. Yes, Mr. Parker.
Well, I can be sufficiently bold as to say I've got 4 points. Hopefully your lordship won't pull that observation apart. My first point is directed to the collective nature of the claim that was being
Collective nature, yeah.
my lord, yes. And on that, we invite the court to read what the judge said at paragraphs 26,
Yeah.
27, page 188.
Yes.
So my learned friend's observation is obviously right. In the context of considering the deal chains, one was concerned with the position of specific claimants. But the judge didn't think that that fact was sufficient to alter the substance of the proceedings as being of a collective nature, given all the evidence with respect to both the underlying evidence frauds that are being operated and the dishonesty of the defendant being presented without distinction. Because I mentioned the telephone calls in this case. As a result of the action against SVS, we were alive to the fact that there was a substantial number of telephone calls in which the brokers had been recorded. And SVS had their recordings, TFS also had their recordings, and one had to go through the totality of the recordings for the purposes of, we said, showing that the brokers were well aware that the so-called legitimate explanation for the volume of trading that they knew wasn't genuine.
Yeah.
So it was, the judge was aware of the fact it was a collective claim, and he proceeded therefore on the collective basis in accordance with what he said in paragraphs 26 and 27. The second point is the fact that my learned friend says, but my proposed order didn't give them their costs of limitation before the settlement agreement. What we had proposed to the judge, again conscious of avoiding unnecessary complexity on assessment, was that we should have our costs up to the date of the settlement, and they should have all their costs thereafter. Now that meant that we wouldn't be getting our costs of having succeeded on 2 on 3, and they wouldn't be getting their costs, their limitation costs pre the settlement agreement. That seemed to us to be a sensible trade-off for the purposes of simplifying the assessment process. As I said when I opened this appeal, we could have no objection if the judge had sort of seen fit to make some deduction to the award of costs in our favour up to the date of settlement to reflect their costs on limitation. The third point.
But the only deduction that you are proposing is the cost of Mr. Hellard's witness statement.
That was the only deduction that we were proposing. We weren't proposing that deduction for the reasons I've just explained. Third point, effect of Part 36 on what we say. We say obviously Part 36, where there has been such an offer, does may enable 1 point to say quite clearly we've won. Part 36 in effect provides for certain penalties as a consequence of Part 36 offers not being accepted. But it doesn't prevent the general rule being applied simply because a successful claimant does not put in the Part 36 offer.
Yes.
And fourth point is, with respect to exercise of a discretion afresh, the court would have noted my learned friend said that there were issues on which the defendants were totally successful and they should have their costs. And for our part, we think an issue-based approach is a sensible. If the trial judge's order is to be overturned, an issue-based approach is a sensible approach to the decision of costs in this case. Once again, thank you very much.
Thank you, Mr. Parker. We will obviously reserve our judgment. You will get the drafts in the usual way. They come with a fierce embargo, which needs to be respected, and a failure to respect it may result in contempt of court. The receipt of the draft judgments will be your opportunity to correct our language and grammar, but not to re-argue points and not to disagree with our reasoning. We would hope that in the light of the drafts you'll be able to agree an order disposing of the various appeals, but if you can't agree an order, please make short written submissions and we will make the order that we consider to be appropriate. Thank you all very much for your help.
All right.